Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officials, listener, learners. All my dear friends, I welcome all of you. It is really nice time, nice place, nice action today. I welcome all respected doctors and directors. I welcome all adorable ministers and managers. I welcome all honorable advocates, retired administrative advisors. I welcome the most honorable President Mr. Modi ji. UnivProfDrRKSMB say it is heartily, cordially welcome of all of you. Nice to see all of you. Nice to listen you. It is really nice time, nice place, nice section today that we are describing, explaining, defining our holy Indian cultural identities, our holy Indian constitutional features in the form of unity and diversity, what is happening around the world, economically, politically, socially, personally and professionally. All of you are listening, YouTube channel 3M Creator. Dear friends, our nation is known by its spiritual, social, cultural, educational values. Since time immemorial, our holy Indian culture, our society has been the symbol for the worldly people. It is an example or lesson for the worldly people. As we see different representatives of the different countries visit our nation at the different time, because our nation is known by the name of starters, beginners, creators, generators, operators, founders of the different missions. To time, when we go into the reading of history, we find that that was the time of 14th, 15th century period when the start of Sikhism, Sri Guru Nanak Dev Ji born in 1469. After that, India was discovered in 1498 by Vasco da Gama. But India existed immemorial times. Since immemorial times, we have history and cultural, spiritual, social values for providing the guidance and supervision to the global world. But nature has been the common concept of all our holy religions of this holy land. Whether we belong to any religion, any caste, color, creed, but we feel the presence of God in the form of ray of light and in the unavailability of ray of light also. So nature cannot be avoided at any rate anywhere. No man is alone anywhere. Human body is made by five elements: air, fire, soil, sky and water. The presence of these five elements, we feel the presence of God or Lord. It is said in all our holy scriptures, time to time, our spiritual mentors guided us. In Satyug there was the age of truth. Just by speaking the truth, we could become able to visualize the presence of Lord or God. Then there was the upper era when people were interested in worshipping statues of gods or goddesses. Subsequently, we find that there was the Treta era when there was Havan or Yog. These were the means or sources for attaining the presence of Lord or God. But in this dark age, if anything is the most fruitful, that is the power of word, the power of sound, power of light, speaking words, listening words, written words, and reading words. These are the most valuable treasure of our human body. It is said in all our holy scriptures by the mentors, directors, instructors of the spiritual education. So let us go through the truth of presence of Lord or God according to our holy scriptures. What are legal services? Let's describe the nature and object of legal services in detail. Legal services has important place in judicial administration. These are legal services which provides protection to justice and make it objective. The meaning of legal services provide service in law field earlier. It was taken as help of law, but now in area has become very wide under the Section 21C of Legal Services Authority Act 1987. It is defined legal services includes the rendering of any services in the conduct of any case or other legal proceeding before any court or other authority or tribunal and the giving of advice on any legal matter. This definition clears two things. One is legal services provided in execution of any case of legal proceeding. Two is it can be in the form of advice in legal subject. But jurist considers this definition incomplete. They say that legal service shall not be available at only during the proceeding of any court, authority or tribunal. Rather, it should also be available before any matter reached to any court, authority or tribunal. It is called pre-litigation legal services as per above the meaning and area of legal services is very wide. It includes legal education, legal awareness, legal literacy, lok adalat, free legal aid, legal advice, compromise, process of legal service. Legal service is provided by two ways before legal proceeding, and altogether prevention is better than cure. It is said in villages that prevention is better than cure. It also applies on legal services. According to this, any matter must be solved before it reaches to any court, authority, or tribunal through settlement or amicable settlement. It has many advantages. The case number shall be decreased in court, authorities, and tribunal. Speedy justice to parties. No necessary expense. Feeling of affection and harmony between parties. Saving the both time and money. It's better to that there is stack of cases in court. Court are under the pressure of excess burden of cases. People didn't get justice for many years. Parties get tired of work to court regularly. Court seems like a mirage to them. The court proceeding is very delayed and expensive. It is a comment on today's judicial system that plaintiff dies but case lives. Case is immortal. That's why people are losing faith in judicial system. Rajendra Singh versus Prem, my AIR 2007 SC 3057. In this matter, Supreme Court said that people are fast losing faith in judiciary due to long delay in disposal of cases. Authorities should do needful to ensure speedy disposal of case. Similarly, in Moses Wilson versus Kasturba AIR 2008 SC 379 in this matter, Supreme Court decided that concerned authorities directed to do needful in the matter urgently before situation goes totally out of control. Court also issued directions. These all are possible if case does not go to court. For example, before going to court, cases must be solved. Provision in Legal Service Authority Act under Legal Service Authority Amendment Act 2002. Provisions is given by adding a new Chapter 6A to solve case by conciliation and compromise. Constitution of Lok Adalats for conciliation and settlement. Section 22C of this Act has provision that any party to a dispute may, before the dispute is brought before any court, make an application to the permanent local adalat for the settlement of dispute. No party to that application shall invoke jurisdiction of any court in the same dispute. Permanent Lok Adalat shall start the proceeding of settlement. Permanent Lok Adalat shall conduct conciliation proceeding between the parties to the application in such manner as it thinks appropriate, taking into account the circumstances of dispute. Assist the parties in their attempt to reach an amicable settlement of the dispute in an independent and impartial manner. If any settlement happens between the parties, then permanent Lok Adalat shall dispose the matter and furnish copy to both parties. Such as disposal of disputes between legal proceeding has become a part of legal service. During legal proceeding, it's a tradition to provide legal services. During legal proceeding, legal services is provided to the parties after the case is presented in court. To those who are indigent and incapable, those persons are provided service of advocates on the expense of states. Basically, it is free legal aid. Free legal aid is a part of legal services. It is provided in Article 39A of Constitution that states shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason or other disability. And provision is given in Section 304 of Criminal Procedure Code 1973 that while in a trial before the Court of Session the accused is not presented by a pleader and where it appears to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. In a criminal case, an accused appeared without his pleader, then court arrest and habeas curia for him, such as free legal aid is provided to parties during legal proceeding by free legal aid. Sometimes locals also try to solve matters during legal proceeding. Advocate Association, Bangalore versus Chief Minister Government of Karnataka, Bangalore, AIR 1997, Karnataka 18. In this matter, Karnataka High Court decided that state shall provide building, library and other facilities to advocates for pleader counsel so that they can work effectively in field of legal service. P. Ramaswamy versus Papamo, AIR 2009 NOC 90 Chennai. In this matter, Chennai High Court said that under legal services, indigent persons should be provided process fee and expense of witnesses. Nature of legal services, it is duty of state to provide free legal aid to poor section of society. It is expected in public welfare state that no person is deprived from justice, especially due to lack of money. It is also provision in 19. It is also provision in 38 9A. MH Horsecute versus the state of Maharashtra AIR 1987 SC 1548. In this matter, Supreme Court decided that it is duty of state to provide free legal aid to poor person, not a compensation. Khalebin Kalabhai Desai versus Allabhai Kalmashi Desai AIR 2000 Gujarat 232. In this matter, Gujarat High Court decided that it is duty of bar and bench to aware women and children from their right of free legal aid. Similarly, in some other matters also it is described. Sukdas versus Union Territory of Arunachal Pradesh, year 1989, SC 991, Hussain Ara Khatun, Home Secretary, Government of Bihar, year 1979, SC 1360, the President of America, Roosevelt, also considered that it is main duty of welfare state, nutrition of social justice. Legal service is a nutrition of social justice. It is important for the execution of concept of social justice that people get free from torture or fear, their basic needs can be fulfilled, and they can get social, economic or political justice. It is also said in preamble of Constitution that that to provide social, economic and political justice, citizen of India adopts Constitution. Legal service is very nearly connected to social justice. The social justice cannot be imagined without legal service. After refutation of social disparity, opportunity of same justice can be provided to socially or economically backward peoples. Energy of rule of law. Rule of law gets support and power by legal services. It is a source of energy for rule of law. Rule of law cannot be imagined without legal service. Main features of rule of law: equality before law, equal protection of law, and of discrimination on the basis of social and economic ground, security of citizens, political and civil rights, equal opportunities before law to every person. Pupils Union for Democratic Rights versus Union of India, year 1982, SC 1473. In this matter, Supreme Court said that poor people also have civil and political rights. They all are also right to get benefit of rule of law, part of natural justice. Principles of natural justice is an important concept of judicial administration. Justice cannot be imagined without following these principles. Opportunity of hearing to everyone is a fundamental principle of natural justice. Without providing the opportunity of hearing, the justice is useless. Powell versus Albano, 1932, 287 US 45. In this matter, it is said that through legal service, poor persons are provided well and experienced pleading and tries to provide proper opportunity of hearing to them. It is provided in Section 303 of Criminal Procedure Code 1973 that any person accused of an offence before a criminal court or against whom proceedings are instituted under this code may of right be defended by a pleader of his choice. Same kind of provision is mentioned in Article 22(1) of Constitution. He can be separated from his this rights. Motibai versus the state, area 1954, Rajasthan, 241. Rights of accused, as per above mentioned, it is right of accused to get legal services or free legal help. It is also his right to get defended by a pleader of his choice. Not only this, now it is considered as fundamental right. Hussain Ashra Khatun versus State of Bihar, year 1979, SCC 1360. In this matter, Supreme Court decided that to get free legal aid is fundamental right of person. In such matters, court should not wait for the application of accused person. Social movement. Legal service is a social movement. When there was no provision regarding legal service before independence, then some social service organizations were providing their services. Many movements were running for the elevation, development, consciousness, and reformation. Legal service is also one of them. It is the result of the movement that today legal services are before us. Requirement of legal services in India. India is a country of villages. Most of its population resides in villages, which is not only poor but uneducated and illiterate also due to uneducated and ignorance. They are full of superstitions and evil. They usually bear injustice, that's why they cannot go to court for execution of their rights. Justice is a mirage for them. There are many hurdles in their way of justice like illiteracy, ignorance, poverty, lack of awareness, superstition, evil and menace, etc. By getting all this, a new article was added in Constitution, Article 39A, so that no person shall be deprived from justice due to economic or any disability reasons. Legal services and free legal aid is its return. It is tried to disable these disabilities by legal services. Legal services are proved very useful and effective. Let's comment on legal awareness and paralegal services. Let's describe its aims and nature of these. Would you suggest about the program of legal awareness along with proved education in India? Let's draw a profile for this program and also discuss about the potential danger and typical heights of this. Legal literacy and paralegal services are important part of legal aid scheme. In today's changing world, day by day, importance of legal literacy and paralegal services are increasing. Now it is felt that without paralegal services, the aim of legal aid scheme cannot be obtained. What are its aims? The main aim of legal literacy and paralegal services is developing legal awareness in public, make the public aware about their legal rights, duties, and liability, providing training to public in law field, providing training to public in law field, legal advice to distressed and victims, inspiring people to solve their masters by mutual settlement, helping sponsors, organizers to organize lok adalats, help to poor and weaker section of society by public interest litigation, the nature of para-legal services and legal literacy is very wide. The mediums by which paralegal services works are paralegal clinic, paralegal training, legal laboratory, legal literacy camp, legal ad camp, etc. Paralegal clinic means such places where legal advice is provided to distressed and victim persons, although for legal aid, now at many places legal aid offices are established, but sometimes to reach at those offices become impossible. In such situations, para-legal clinic is a blessing for people, blessing for public to provide legal advice and aid on these clinics. Time to time, services of experts are available. Generally, these services are provided by advocates, teachers, and students of colleges and universities and social services. These services are sometimes called as legal ambulance. It is very much famous in Gujarat, such as medical help is provided in hospitals immediately. Similarly, legal aid is provided to needful in law sector. Weekly Indian dated 20th February 1983. The ex-Justice of Rajasthan High Court Mohanlal Shrimal once said that courts must work as hospitals or clinics, then poor person shall be benefited. Rajasthan Patrika, dated 24th January 1983. Where the question of establishment of such clinics according to higher committee paralegal clinics should either be run by law faculty or students of law must be related to this legal ritual. Dr. Tripathi, second edition. at page number 497. According to P.N. Bhagwati, it would be very useful for us to connect students with legal aid programs. But the problem is that we do not have any such plan to inspire students in this regard. That's why now students are not able to use their power fully. If we could start such clinics in the colleges and universities, then that could be creative proceeding of the workshop on establishment of legal services, Lucknow, 18th October 1981, according to P.N. Bhagwati, Economic. There are the benefits to connect students with paralegal services. If students are attached to paralegal clinics, then the expense of work gets less. Participation of advocates can make it expensive. The expense of advocates can be saved by connecting students to this social obligation. Due to this, the feeling of social obligation developed in students. They will get in touch with poorer and weaker section of society, will understand their problems and will execute their social obligation by helping them. Introduction to problem. When students will connect